The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your podcast on the Federal Courts of Appeal. I'm your host, John Ross, joined by Sheldon Gilbert, Director of IJ's Center for Judicial Engagement. This week, we have a special show featuring the Harte family, whose home was raided by a SWAT team on, in the words of the police, a day to fear for marijuana growers. But instead of marijuana growers, the police terrorized an innocent, sleeping family. Believing the raid violated the Fourth Amendment, the Harte family filed a lawsuit. We interviewed Addie and Bob Harte, who will tell us what it's like to endure a SWAT raid and about their efforts to obtain some measure of justice in the 5 years since the raid. One of their attorneys, Rob Bernstein of Kirkland & Ellis, is in the studio with us today. Because of the length of today's show, we'll take brief intermissions around the 22 and 37-minute marks. Rob, tell us about the Harte family.
Bob and Addie Harte are a suburban Kansas City couple. They met in 1989 while they were both CIA employees in Washington, D.C. They were different. She was Jewish, he was Catholic, she was a Democrat, he was a Republican, but they shared a love for country and shared a love for family. And in 1999, they left the Beltway to move to suburban Kansas City to raise their children. At the time of the events that we'll be talking about, they had a son in 7th grade and a daughter in kindergarten. Addie was a graduate of the local Citizens Police Academy. She worked as an attorney at a local asset management company, and Bob is a stay-at-home dad.
Rob is in the studio with us right now, but we spoke by phone with Addie and Bob last week, and we will be playing clips from the interview throughout the episode.
My name is Bob Harte. I live in Leawood, Kansas with my wife and kids. I've been a stay-at-home dad for a number of years.
My name is Addie Harte, and I'm married to Bob for 20-something years right now. I'm, essentially a suburban mom who works full-time while my husband stays home with my kids. It's been that way for a number of years. And I guess I pride myself in having the utmost of integrity and doing the right thing and teaching my kids what right and wrong is, and have a history of being working for the federal government, so had a lot of expectations about what good government is. And we're sort of in the aftermath of what happened to us, dealing with those things for ourselves and for our kids.
I've always considered myself a patriotic American. Thomas Paine said the role of a patriot is to protect your country from your government. And I was kind of like confused. I just didn't know. I just, equated country and government before this experience.
So, Rob, these are patriotic people. They're certainly not anti-government zealots. Addie was a graduate of the local police academy. How do they find themselves in this situation?
Well, in February 2012, the Johnson County Sheriff's Office in Kansas began planning a day of raids that would occur on April 20th, 4/20, the day associated with marijuana usage. The Sheriff's Office envisioned a day of raids around the Johnson County area to, in their words, teach the marijuana-using community a lesson. One of the organizers stated that 4/20 will be something to fear rather than something to celebrate. By March 20th, the Sheriff's Office did not have any leads on whose homes to raid. As it turned out, the Sheriff's Office had actually prepared a press release prior to April 20th touting their success in what the Sheriff's Office was calling Operation Constant Gardener.
So basically, they've created a situation where they're under a lot of pressure to arrest somebody, to do something on April 20th.
That's right. They had pre-committed to what the Sheriff's Office called a full-throttle day of raids, but they didn't begin investigating anyone until March 20th, 4 weeks before D-Day, before Raid Day.
Wow. So and this is what basically gets the Hartes kind of in the crosshairs of their police department.
And this is Addie and Bob, in their own words, how that morning transpired.
It was a Friday morning, obviously April 20th, it was 2012, and I was in bed. My alarm went off at 7:20 in the morning. It's just the standard time to get the kids from school and get everybody out of the house. So I was sitting on the side of the bed after the alarm went off, okay, it's Friday, and probably about 7:22, and just this banging that there is no word for in the English language to describe. I mean, you can't imagine the banging. And the house to the south of our house had been vacant for several months. And I thought, my first thought was, well, maybe there's something going on next door. and that maybe there's something I haven't noticed in the vacant house, and I got up to look out the window, and then I heard the banging again and realized my front door is coming off the hinges. And I ran upstairs. I just had on a pair of gym shorts and, got to the door. There's a small window, maybe about a 1-foot square in the door that you can see out. And I could see the guys, I guess they use the term stacked, ready to come in. And I reached out and opened the door, and it was game on. I mean, instantly I was on the floor, guy standing over me with an AR-15. Everybody's yelling, are there children in the house? Are there children? Where are the children? Didn't know who these guys were. I've said before that at that moment when they come in like that, forget the Bill of Rights, forget the Constitution. The only right you have is a right to not get shot if you cooperate. And it's like a harsh reality.
I hadn't slept that well, and I had been woken up by some kind of rustling on the side of the house. And so I was still in bed and kind of groggy. And when all of this happened, I will say that in addition to the banging so much so that the windows were rattling, there was screaming, and even before they came into the house. And in my grogginess, I just pulled the covers over my head and hoped it was a bad dream. And then when I heard the officers come into the house and start screaming about my children, that's when my mother's instincts kicked in. And I jumped out of bed and went downstairs. But as I walked down the hall, my kids had gone down ahead of me. So what I saw was just a stream of people flooding into our house. I came down the stairs, and as I turned into our foyer, I saw Bob face down, shirtless, hands behind his head, with an AR-15 over him. My kids and I were ordered to sit cross-legged against the wall.
First of all, when you watch the cop shows and the cop movies, they always come running in, holding up a piece of paper saying, we have a search warrant, let us in. In the state of Kansas, they don't have to show you the search warrant until they leave. So we really had no idea what they were doing.
We had asked for the warrant early on, and they specifically told us that they did not need to give it to us until they left. So we were there completely confused until towards the end. So in that moment, we were just convinced they were in the wrong house. We were screaming at them, "You're in the wrong house! You're in the wrong house!" Trying to get information. And I don't think you can adequately describe the terror and the confusion, of that moment.
That is just crazy, listening to Bob and Addie describe what it was like. I'm having a hard time imagining how I would react if all of a sudden, early in the morning, police just start streaming into my house. This is just one of those experiences that's just a nightmare to even think about happening in your own home.
Bob says that, at that moment, your only choice is really comply or something very bad is going to happen and your constitutional rights are straight out the window. Rob, what's your reaction to that?
I think Bob's right. I think at the moment, most people are not talking about not thinking about their constitutional rights. It is true you have a Fourth Amendment right not to have the police use excessive force against you, and you have a right not to make a self-incriminating statement. But I think in the heat of the moment, most people are thinking about survival and the welfare of their children.
Yeah, so basically, as Bob says, it's, I think a lot of us who are exposed to criminal law and criminal procedure through TV shows, as Bob says, we kind of have this picture in our mind where the police knock on the door and they, maybe hold up the piece of paper that says, we've got a search warrant, and then we have, the guy kind of carefully reading through the search warrant and saying, well, don't touch this, touch that. That's not really what it's like. It's more intense. It's more like, an army invading your house, and there's really nothing you can do but hope that, you and your kids and your family don't get shot.
I think that's a correct description. The police officers in this instance were in the Harte's home for several hours, rummaging through every corner of the home. After 90 minutes, a canine comes in the house for an hour and to search and doesn't find anything. One of the deputies, Deputy Shoup, states that on the way out of the house, he told the family that they should all have a sit down and just be honest with each other and talk about their drug use.
So this is part of a larger operation. Were there any other raids that day?
The sheriff's office conducted a total of 4 raids that day to look for marijuana as part of this Operation Constant Gardener. The sheriff's office ended up not finding any marijuana that day, but amazingly, Sheriff Denning went forward with a press conference that afternoon. We know that in the afternoon, he emailed his command staff and said, the drug raids are not going well at all. Cancel the press conference. But in an instance of truth being stranger than fiction, the press officer responds that the media are waiting in the next room. The sheriff says, reluctantly, I will go forward with this news conference. He steps behind the news curtain, and there's video footage, which you can see online, of the sheriff speaking in front of a knee-high pile of marijuana plants, warning about the dangers of marijuana usage, even though the office had not actually seized any marijuana that day.
But he's got the press waiting for him. He's supposed to give a statement. So he walks out, and they've created this this visual of knee-high pile of marijuana to show how dramatic their raids have been and how successful they've been. But they didn't actually, find any marijuana that day.
That's correct. Operation Constant Gardener was a publicity stunt. Before the sheriff's office had even started investigating any families, they had issued a press release and invited the media to a press conference.
Well, let's go back to a clip because Bob and Addie at this point don't know any of this. Let's go back to their perspective.
And neither of us had ever, and still has never, used marijuana. And it wasn't till the very end when they told us they were going to treat this as a personal matter and essentially accused our son of being a pot user. We should take him to the doctor and have him tested for marijuana use. We should have a family meeting, all these things. And I kept asking questions. Well, what did you find? What do you think? Because if I'm going to I said, if I'm going to rip this kid a new one, I need to know what the facts are. We discovered that in the state of Kansas at the time was I think the only state in the country where search warrant affidavits are not essentially publicly available, if not to the individual who was the subject of the warrant. So it was a long process, and Cheryl requested the records under the Kansas Open Records Act, and that was twice denied. I mean, it was a whole long process, but I'm also someone who just will not sit back and be a victim without understanding what happened, right? So it was never a question for me that we had to find out what happened, and we're not going to back down, and we're going to try to right this wrong. And it sounds like sort of a trivial distinction at some point, but it wasn't until a year or so later that we found out it wasn't seeds and stems, it was wet leaves and stems. And so a year later, we finally understood that it was it had to be my tea leaves, because wet leaves could only have been tea leaves at our house.
The tea leaves were found in the family's trash outside their home.
Why does it take a year to realize that the police have been going through her trash?
Well, under Kansas law at the time, if your home had been raided, if you'd been the target of one of these raids, the sheriff's office didn't just hand over the records under the Kansas Open Records Act. In fact, after the raid occurred, Bob and Addie started asking questions about why did this happen to them. The sheriff's office, in fact, didn't release any of the records until the Hartes initiated open records litigation in state court and invested about $25,000 into trying to figure out how their home was raided.
So this couple had to pay $25,000 out of their own pocket just to get the police to give them the record saying why on earth the police had come, knocking on their door, or rather I should say knocking down their door in the first place.
That's right.
When they get those records, they find out that it's pretty likely that the substance, it's agreed that the substance that the police actually found in their trash were wet tea leaves. How on earth do the police confuse wet tea leaves for marijuana?
Well, it's a good question. We don't think that any reasonable police officer should be confusing wet tea leaves for marijuana. And in fact, that's exactly what the sheriff's office own crime lab said. And the months after the raid, the sheriff's office did eventually submit this green vegetation, this material found in the family trash, to the county crime lab. According to the county crime lab's report, chemical testing on the green vegetation was seemingly unnecessary because, according to the report, the green vegetation, quote, did not look anything like marijuana leaves or stems.
So months after the raid, they finally send the plant matter to the lab. What on earth were they doing before those months that made them feel that they should initiate a raid?
Well, the story really starts with a Missouri highway trooper, Trooper Wingo, and that's his actual name, who for several years had been parking his patrol car outside of indoor gardening stores. And he said that he would sit in front of these gardening stores for several days a week, several hours a day, and write down the license plate numbers of the individuals coming out of the gardening stores. In 2011, he persuaded local law enforcement agencies to conduct the first Operation Constant Gardener in 2011, the first day of raids around the Kansas City area. And then in 2012, the Johnson County Sheriff's Office wanted to replicate these day of raids. In March 20th, Trooper Wingo provided a spreadsheet of names to the Sheriff's Office. And on this spreadsheet was Bob Harte's name. Bob Harte had shopped at an indoor gardening store in August 2011. This is 8 months before the raid to his house. And then it's in March when Wingo gives the name to the sheriff's office that the Hartes officially become a suspect.
What did he purchase at the store?
Bob Harte, according to Trooper Wingo, was seen walking out of the store with a small bag. Bob Harte was at the store that day with his seventh grader to buy science project materials. He was trying to grow a hydroponic tomato garden as a science project with his son.
You've got a cop who's just watching anybody and everybody going out of a gardening store, and anybody who leaves a gardening store gets added to a list that is a list of potential suspects, right? That's what it sounds like.
That's exactly right. Trooper Wingo said that he would sit outside the store and write down a description of the individual, write down their license plate number, and write down what he saw them carrying. And he compiled this information into a spreadsheet. And then he would share the spreadsheet of gardening store customers with law enforcement agencies around the Kansas City area. And then agencies would use these tips, if you want to call them that, to begin marijuana investigations.
Okay, so the Harte's name gets added to the list because Bob Harte made the mistake of taking his son to go get the materials for a science fair project. Okay, and the police 8 months later are under pressure to do some drug raids. They see that this guy named Bob Harte was at a gardening store, so they start rummaging through his trash. They call it trash pulls, I guess, and they find this wet leafy substance in the trash that, as we talked about later, months later they submit to a crime lab. But what did they do with that wet leafy substance at the time? Or what did they claim that they did with that substance when they first came across it in the trash?
The deputies first visit the Harte's home on April 3rd, and according to their police report, they found wet green vegetation that was innocuous. They leave the home, but the clock is ticking until Operation Constant Gardener on April 20th. The deputies return 1 week later, and they say that they find the identical green vegetation in the family trash. And then they come back on April 17th, and they find the same vegetation. According to the deputies, they field tested the substance with drug field tests, these pocket field tests. And according to the deputies, the green vegetation field tested positive for marijuana, for THC.
If kind of a chemical test is saying that this leafy substance is marijuana, that kind of sounds bad for the Hartes here. Can you tell us a little bit more about this test?
Well, these are pocket tests that law enforcement agencies around the country use to identify suspected illegal substances. They're often taken out of a pouch. They involve breaking a tube, mixing chemicals together. These tests, however, assuming the test was even used that day, these tests have a distressingly high false positive rate. The test that the deputies claim to have used that day has a false positive rate of about 70% and tests positive for a variety of substances, including caffeine.
Let's say that it's even, it's testing positive. All from a positive test result is that it might be THC, but it also might be caffeine. Is that right? That's all the police can know, is that it's positive for any one of the things that it tests positive for?
That's right, although the deputies did not seem to know much about the field test that they claim to have used. The instructions on the field test, the label on the field test that they say that they used states that a positive result at most provides a basis for police officers to take a suspected substance into a crime lab for chemical testing.
Right, but they didn't do that until after they did the raid.
That's right.
Wow. So all they know is it tested positive, but it could have been positive for caffeine. It could have been positive for anything else. And even though the directions say, hey, after you test positive with this little sample test, you need to go send it to a crime lab to figure out if it is or isn't, they didn't do any of that.
That's right. And there's an additional wrinkle here. As it turns out, the kind of drug field tests that the deputies claim to have used, the chemical that they say that they used, it turns out that this type of field test wasn't even authorized for testing natural marijuana. The test that they claim to have used is used for testing synthetic cannabinoids like K2.
So even if they'd had marijuana, this test wouldn't have been able to test for natural, organic, I guess artisanal small batch marijuana, right? I mean, it's a type of test that's used for synthetic products. That seems kind of reckless that the police would rely on something like that as the basis for deciding to bust down somebody's door, and run in with AR-15s.
We think so. In the aftermath of the SWAT raid on the Harte's family home, the sheriff's office sends out a memorandum and bans the use of this particular drug field test for testing natural marijuana.
Rob, you've mentioned a couple times that the police claim they performed a test or say they performed a test. Is that a disputed fact?
There's extensive evidence in the record that the deputies lied, that the deputies never conducted any field tests. They were operating under a ticking clock to complete their investigation before April 20th. I think it's also possible to infer from the evidence that the deputies conducted the tests but lied about the results.
At this point, we'll take a brief intermission. For links to the decisions and articles we're discussing, check the description page on SoundCloud and iTunes. In addition to the Short Circuit podcast, we produce an email newsletter that summarizes 15 or so federal appeals court cases each week. The roundup is slightly irreverent and always informative. Subscribe at ij.org/short-circuit, or look for it every Monday on the Volokh Conspiracy blog at the Washington Post. And now back to the podcast, which will start off with Addie Harte reacting in the aftermath of the raid.
Honestly, for us, but also there's this recognition, and was this recognition, that if this can happen to us, and we had nothing to hide, essentially, what did it mean for everybody else in lesser, circumstances who didn't have the money or the education or the or other resources to pursue this? It meant to us, and we discovered pretty quickly, that this was happening to people all over the country who really couldn't do anything about it.
So a year after the raid, the Hartes finally get some traction with their open records lawsuit, and a picture of what happened starts to emerge. Some months after that, they file a federal lawsuit with the aid of Cheryl Pilot. Rob, tell us about that lawsuit and what were some of their claims?
Well, all this information is what we know from years of discovery. Cheryl Pilot, the Harte's counsel, spent years fighting with the sheriff's office to obtain all this information. And Cheryl compiled a summary judgment record that I think should be a case study in trial advocacy classes. And it includes 18 depositions, hundreds of pages of documents and emails. This was a record that every appellate lawyer dreams of. And most of what we know about the case comes from this record. Based on this record, and the Hartes were able to present a variety of claims. The Hartes filed a lawsuit in federal court under a federal law. It's called Section 1983 of Title 42 of the United States Code. It's a strange title, but this is a federal law that allows individual citizens to sue local law enforcement officers for violations of the Constitution. But it's not quite that simple. The Supreme Court has developed a doctrine called qualified immunity that essentially protects police officers when they violate the Constitution. And this makes sense. We don't want police officers getting sued left and right every time they exercise their best judgment, but perhaps accidentally do something wrong. In order for a plaintiff to succeed in one of these 1983 lawsuits, and in order to overcome the qualified immunity doctrine, a plaintiff needs to show that at the time of the alleged acts, every reasonable officer would have known that what he or she was doing was wrong. Essentially, a plaintiff needs to show not just that a police officer violated the Constitution, but that they did so in a really egregious way.
You described qualified immunity as kind of a significant barrier to being able to hold the government accountable when they violate our constitutional rights. And I agree. It sounds very reasonable to make sure that there are safeguards so that cops aren't constantly second guessing themselves. But the way that we've kind of described what happened to the Hartes, this isn't an example of a heat of the moment situation where somebody draws on a cop and the question is whether or not the cop used excessive force in responding. We're talking about kind of a premeditated, PR-driven plan to raid people's homes to be able to have a press conference. And then you've kind of described this series of really outrageous type of conduct, like relying on a test that gives false positives if it's caffeine, not sending something to a crime lab before you press forward, just picking out anybody that happens to have gone to a gardening store. Like that seems to me that there's, as you've described it, how can that possibly be the type of facts that would, nonetheless give rise to qualified immunity?
The Fourth Amendment, and I think this is a point that's sometimes misunderstood, the Fourth Amendment does not require police officers to obtain a warrant before going forward with a home search. But the Fourth Amendment does say that no warrant shall issue but upon probable cause supported by oath or affirmation. And in 1978, the Supreme Court, in a case called Franks v. Delaware, held that these words, oath or affirmation, are extremely important. When a police officer makes a representation to a magistrate judge to obtain a search warrant, we presuppose that the statements made to the magistrate judge are going to be made truthfully and that they are going to be made not with a reckless disregard for the truth.
So the lawsuit is about what the police did to get the warrant, and then on the back end, how they executed the warrant.
That's correct. One of the Harte's claims in their complaint is that the evidence in the record would allow a jury to conclude that the police officers intentionally lied in their warrant to obtain the search warrant, or that they recklessly represented the truth. And then a second independent claim.
And that's the Franks claim.
That's correct.
Okay.
That claim is based on the Supreme Court's decision in Franks v. Delaware. And then independent of that claim, that even if everything with the search warrant was kosher, the deputies nonetheless violated the Fourth Amendment in executing the search.
Okay, and in what way did they violate the Fourth Amendment? Does your client argue in executing the search?
Well, the police officers had a search warrant that allowed them to look for marijuana in the family home. They've stated that within 20 minutes, they concluded that no marijuana grow operation existed, but they continued to rummage through the family home for several hours, searching every corner of the home, in their own words, looking for evidence of any kind of criminal activity. Essentially, they were just trying to get the Hartes in trouble. They were acting as if they possessed what's called a general warrant. This is what the framers reviled, and this is one reason the Fourth Amendment was enacted, was to prevent law enforcement officers from just entering your home and just looking for anything, looking for any kind of crime.
So to just put it in plain language, sure, the magistrate judge said, okay, I think you've got enough here to go check and see if there's a marijuana farm in the basement, but I didn't say that you could stay there for 3 hours and look for whatever you want of violation of any other crime.
That's right. That's the second claim in the case, the claim relating to the unlawful execution of the warrant.
Rob, if I can back up, you said something a while back that I think is actually kind of noteworthy and a little incredible for a non-lawyer. You mentioned that a warrant isn't actually required. And as someone who used to have a come back with a warrant doormat in front of his door. That's pretty disturbing. How is it that a warrant isn't required by the Constitution?
That's correct. The Fourth Amendment does not mandate that police officers obtain a warrant before they conduct a search. The warrant requirement was actually included in the Constitution partly to provide a shield for police officers. The idea was that if police officers wanted to go and conduct a search, they could do so. But if they trespassed or if they did something wrong, they could be liable to the plaintiffs under state tort law. But by going to a magistrate judge first and asking, "Mother, may I?" a police officer could obtain a warrant and then go forward with the search and have a kind of shield if something went wrong in the execution of the warrant.
So all those folks out there who have come back with a warrant doormats, take note, because you're actually just asking the police to make sure they're shielded from liability.
So what should our doormats stay instead? Like what should be the thing that we have on our doormats?
We don't consent to a search.
Please don't shoot me, to go back to Bob Hart's point. The only right you have at that point is to just, try not to get shot by the police.
I think there's a lot of truth to that. We talk a lot about law and theory, and Fourth Amendment jurisprudence as developed by the Supreme Court is known or is infamous for being extremely complicated and nuanced, but that's not often how the doctrine isn't how things play out for ordinary people. And, I think this case shows that very, very well. At the moment when you have 7 officers and an assault rifle in your home, you're not thinking about Fourth Amendment jurisprudence.
So Fourth Amendment jurisprudence is indeed very complicated, as the Hartes soon discover when they get the decision from the district court.
It was right around Christmas time, and our attorney heard before we did.
We heard about the ruling. It happened to be the Saturday before Christmas, 2015.
And we were all just heartbroken and in a state of disbelief. I don't know how else to describe it, because to us, who are not constitutional lawyers, it's just so obviously wrong what happened to us. And to our children, I don't know how do you explain that what they went through is okay in the eyes of the law.
Just devastating. You can't explain how devastating it is. At that point, I think Addie and I personally were out of pocket close to $100,000. We had hundreds of thousands of dollars in, billable hours with our attorneys. We had been all over the local news on at every step of this. When we lost, it was my picture in the Kansas City Star. It was very public, and I didn't care about the money. I didn't care about losing publicly. It was just this sense that we officially do not live in a free country. We don't have a constitution that protects us from our government. The Fourth Amendment is at best a suggestion.
So obviously the district court doesn't go in their favor. And then soon after, Rob, you joined the case. Tell us about the decision and about how you became involved.
Well, the district court throughout the entire case at summary judgment. Summary judgment is the point in the lawsuit when the parties have had time to conduct discovery to gather their facts. The district court said that even looking at all of these astonishing facts that we've discussed, there was no way the Hartes could overcome the qualified immunity barrier.
So there was no need for a trial. There was no need for further proceedings.
That's right. It doesn't even let the jury decide the facts.
Bob says that when he read that decision as a non-lawyer, it feels like something that should obviously be a constitutional violation, the courts have decided is not a constitutional violation. And a lot of the work that's being done here in this decision is the court saying that under qualified immunity doctrines, the police basically get to go scot-free for the behavior that they were involved in. And this is troubling. This, to us, sounds like the Supreme Court has taken a left turn somewhere, has misinterpreted the Constitution, and hasn't been applying it in the way that the founders or framers, designed it to be applied. And the result is that, as Bob feels, there is no protection from your own government, and that's troubling. And it's not just the Hartes. They described that that they heard from, many, many other families that they'd experienced kind of the same type of abuses. And the doctrine and qualified immunity seems to be driving a lot of this.
It's a tricky doctrine, and the doctrine does do good work. We don't want courts second-guessing the decisions of police officers in every instance. Police officers make thousands of decisions every day, and we don't want every decision to form the basis of a federal lawsuit. But the line drawing is difficult. We also don't want to afford police officers carte blanche. We don't want to afford them a clean slate to act however they want, and we don't want to isolate them from the Constitution. No one is above the law.
I think that's a great way to put it, and that's how we might describe what we'd call judicial engagement, a type of judge that doesn't reflexively defer to the government, but we also want judges to dig into the facts, figure out what actually happened, and not just reflexively defer to the government. On the other hand, I've seen plenty of academic literature by professors Chris Walker and Aaron Nielsen looking at qualified immunity decisions from across the country, and it kind of looks like it's a very, very, very heavy pro-government thumb on the scale in balance, and it makes me wonder if we've gone way too far. The courts have gone way too far in qualified immunity and are just being too reflexively deferential to the police, and it might be time for a significant shift in that regard.
Qualified immunity is indeed a heavy thumb on the scale in favor of public official defendants. I don't believe in judicial activism, but I do believe in constitutional activism. I mean, all judges should be vigilant when it comes to protecting civil rights and civil liberties.
Rob, so at this point, after the district court decision, you read about the case in the newspaper. Tell us about that.
In December 2015, right before the holidays, I saw a story in the Washington Post by a journalist, Radley Balco, about the district court's dismissal of the case. The headline was something like, "Federal court holds shopping at gardening store, drinking tea leaves, subjects you to a SWAT raid." I was outraged by the article, but I thought the article may have perhaps unfairly represented the district court's opinion and unfairly represented the law, as sometimes happens. So I went online and I read the district court's opinion, and I was even more outraged. The district court opinion, as an appellate attorney, struck me as a probable reverse for liberal judges, conservative judges, across the ideological spectrum. The case struck me as an opportunity to do something good for clients who'd experienced a great injustice, and also as an opportunity to move the direction of Fourth Amendment law in a better direction. I approached the partners at my law firm, including Paul Clement and Viet Din. I explained my thinking, and they agreed with my assessment, and they were very supportive of the idea of reaching out to Cheryl and the Hartes to offer our services on appeal and to see if we could do something good in the case.
And now the second and final intermission. As we mentioned, we have posted links on our iTunes and SoundCloud pages to the decisions and articles featured on the podcast. If you have any questions or comments about the podcast, email us at shortcircuit@ij.org. Thanks for listening. We appreciate you. And now, back to the podcast.
So can I just say for a second here, there's a lot of pieces that you have mentioned here that I think are important to tease out. First of all, you as an experienced, appellate litigator, you find out about this case because some journalist took the time to kind of dig into an outrageous story, an outrageous decision, and splash it across the pages of the Washington Post. And that doesn't happen in every case. But it, I think, emphasizes or puts a light on how important it is to have reporters out there really covering, these stories where the government and the police are really abusing their powers. I think that's one remarkable piece of what you just described. And then the other piece is that, frankly, this happens so much that you don't have most of the people who suffer raids like this, they don't have access to a Cheryl Pilot who is going to be able to spend years taking 18 depositions from the cops and spending years, dragging the cops to the courts to get access to the documents you need to make a claim like this. Most people don't have access to, a top flight DC appellate firm to represent them. And that's what I find most troubling about this. I think it's fantastic that the Hartes in their individual capacity, put the time and the resources and submitted themselves to kind of the pain of this entire process. I think it's fantastic that they had great legal counsel. But what troubles me is that this is just the tip of the iceberg, right? Not everybody is the Hartes. In fact, most of the people who are going to get raided, they're never going to have access to the resources that the Hartes had to really fight this. And I find that kind of troubling.
I think that's at the heart of this case. No pun intended, truly. The Radley Balco, the journalist who wrote that article, has been calling attention to this issue of police militarization for years.
Is this the guy who wrote Rise of the Warrior Cop?
That's right.
Yeah.
Radley's work plays an important role here. And Bob and Addie Harte are my heroes for their willingness to put themselves in the public spotlight and to wage this fight and to ensure that this doesn't happen to other families.
Okay, so fast forward how much longer? Another year before you argue in Denver before the 10th Circuit Court of Appeals?
My law firm became involved in January 2016, and oral argument was later that year, November 2016.
And I happened to be in Denver at that oral argument for a different case on the same day. And I remember, watching Rob's argument and hearing the judges go back and forth. But what I remember most is that I kind of turned to my right, and I saw this family sitting in on one of the benches to the right of me. And I kind of guessed that it must have been the Hartes because I could kind of see them very closely paying attention to every single word that came out of the lawyer's mouth or the judge's mouth. And you could even kind of see some emotion on their faces during the argument. And I was impressed to see that you had the family and these two children with them in court.
It was really important to us that we all be there for the process. And again, I want the kids to understand that we live in a country where we can fight back, where we can push towards doing the right thing and having the government do the right thing.
I wanted our children to be there. Most of what we had done before that point, they couldn't really participate in. My son sat in one time when we testified in the state capitol in Topeka, Kansas, for the open records law. But I wanted them to be, feel like they were doing something and to kind of understand what we were doing. But I also wanted those judges to know that, their decisions are not like academic white papers where they can put forth postulate theorems about how an ideal utopian society might work, that their decisions affect every single home in this country.
Remember, the Hartes are from Kansas, and this case is being heard by three judges, a panel of three judges, in the seat of the 10th Circuit Court of Appeals, which is a court that covers basically most of the Mountain West and then Oklahoma and Kansas. So the Hartes have to take, themselves and their kids all the way from Kansas to Denver, Colorado, to be able to sit in this very august room and listen to this argument. And I think it's fantastic that they were willing to make that sacrifice so that they could teach that civic lesson to their kids. I think that's really powerful.
And here is a clip from the argument.
When all you have is a man walking into a hydroponic store with his two children months earlier, and then suddenly, as we're moving toward that all-important date, 4/20, we've got to do trash pulls from this man's house. And you've got to be thinking, these two officers better be thinking, wow, we got to have more than, we need to substantiate that this trash pole and this leafy vegetation that we don't know what it is that we found in the trash, because that's all we have. And maybe because all they had was a man and his two children walking into a hydroponic store months earlier.
And they had a long, long history of making many, many cases out of this same investigative pattern. Long history.
I don't know if you want that to be your argument.
We know that the KN reacts to THC. Now, we also know it reacts to caffeine.
Look, this is involving people's lives and liberties. We're talking about criminal law here. A test that is reactive to caffeine is going to be legitimate to test for marijuana?
Well, sure.
I mean, that to me seems reckless on its face.
Well, the Kansas legislature didn't think so.
What I'm saying here is the Kansas legislature cannot make science. If you have a test that reacts to caffeine, and it's precisely what happened here. Apparently there was caffeine in the tea leaves, and it reacted to the caffeine in the tea leaves, right?
Apparently, yes.
Yes. Now, how can that test that has that level of falsification possibly be used to test for marijuana, and not only test for marijuana, to bring in SWAT squads to arrest people is beyond me.
Well, the test is that it continuously, consistently, and uniformly tests positive for THC. In the scientific lab world, that is a reliable test, to test for THC.
Is that true if it also consistently and reliably reacts positively to caffeine?
Yes, because there are other factors.
I rest my case. The headlines in this case would say 10th Circuit panel rules that a positive reaction to caffeine or THC from tea leaves found in the trash receptacle of a respectable Kansas family, coupled with the entry into a garden store, constitutes adequate proof, adequate probable cause to call in SWAT teams. I think that might be a good headline in the Onion, but I don't think it's going to pass the laugh test with any other newspaper in America.
And the facts are even worse, because the father in the home is laid down on the floor. We have people in there with guns. The wife and the kids are brought down, sat on the chair. Do you stop and think, as far as you defend this, and yet you have this family with these young children. This is their impression of the police and how the police work. That's my frustration with your argument today, is you just seem to think no big deal and pedal to the metal.
So you just heard from all three judges, Judge Moritz, Judge Lucero, and Judge Phillips, and the government's attorney, and I have to say that sounds pretty promising.
Yeah, I think, at one point, Judge Lucero, I think, said, "I rest my case," and he kind of stole your line, Rob. That's what you're supposed to say. It's got to feel pretty good to have, the judge on the bench say something like that.
I wasn't counting my eggs just yet, but it was a good sign.
Yeah, well, look, I get every appellate lawyer I know says the same thing. You can't read too much into oral arguments. You never know how things are going to go. It's hard to predict. I totally get that. But come on, that sounded really good for your side. All three judges were hammering that government lawyer. And if I had to guess how that case was going to end up, after listening to it and I was there, I would have felt pretty optimistic. This was going to turn out pretty well for you guys.
Well, Sheldon, after the argument, I would have rather have been us than them.
Tell us about the opinion.
The 10th Circuit reversed on a majority of the claims in the case and affirmed on some of the claims. It was an unusual decision. It was a 100-page decision in which each of the three judges on the panel wrote a separate decision. So the opinion was seriatim in the style of the early United States Supreme Court, and each judge almost found a different part of the case to be outraged by. The facts in this case are so astonishing, and there are so many layers to the onion. Judge Moritz, focused on the possibility of untruthfulness in the police investigation. Judge Phillips focused on the excessiveness of the search itself. Judge Lucero was rightly so outraged by everything. He described the facts as too rich for fiction.
Yeah, actually, can I read the first paragraph of the opinion? Because I think it's worth reading before we hear, the Harte's, their reaction to reading the opinion. This is Lucero, circuit judge. Quote, "Law-abiding tea drinkers and gardeners beware. One visit to a garden store and some loose tea leaves in your trash may subject you to an early morning SWAT-style raid, complete with battering ram, bulletproof vests, and assault rifles. Perhaps the offers will intentionally conduct the terrifying raid while your children are home and keep the entire family under armed guard for 2.5 hours while concerned residents of your quiet, family-oriented neighborhood wonder what nefarious crime you have committed. This is neither hyperbole nor metaphor. It is precisely what happened to the Harte family in the case before us on appeal," end quote. And I got to say, when I read that first paragraph, and John read that first paragraph and sent it to me, I thought this has to be a slam dunk, decision. But after reading that first paragraph, I saw that there are 100 more pages of, or rather 99 more pages of opinion after that. And I started to wonder why on earth, given that powerful opening paragraph, this is going to be as complicated as it was. And it sounds like the Hartes kind of had the same reaction.
So the first thing we heard was a text from Cheryl and saying, check your email, we have big news. So I had been pretty anxious about it and Googling myself in the 10th Circuit every day for several weeks. But I was at work and I saw that and I checked it. And initially it was, just almost a sense of euphoria, that we won, right? And then I started reading the opinion, and the Judge Lucero's opinion is amazing, right? And it's just like, yeah, right? But then we get to, I think Judge Phillips was next, and then it's just like, oh, it wasn't quite as positive. I'll just put it that way. And then that gets to be kind of disheartening. And then you move on to Judge Moritz, which was sort of somewhere in between. And so it was a bit of a roller coaster, I'll say, from, wow, this is amazing, to, okay, what does that mean to us? And then, in our case,
as a non-lawyer, this just doesn't make sense to me, none of this, the past 6 years. And I'm still kind of learning and trying to piece it together. And, when I read the 100-page opinion, and it took me days to process it, I think what I felt was the raid on her home was a very clear violation of the Fourth Amendment. Any fourth grader could read, in social studies class could tell you that. Everybody knows that. But it's not a violation of the case law. And, with the case law, they have sliced and diced and made julienne fries out of the Constitution so many times that there's nothing left.
Sheldon, do you know what julienne fries are?
Yeah, so I love when Bob describes the case law, basically the cases that have interpreted the Fourth Amendment as slicing and dicing the Fourth Amendment so finely that he's turned it into julienne fries, or really thinly sliced fries. And if a non-lawyer, I think, can appreciate better than a lawyer the frustration with an opinion like this, where there are some good pieces to this opinion, and that you have kind of this mixed bag is frustrating, and it makes you wonder, again, like we've said, whether or not Fourth Amendment jurisprudence has taken a left turn somewhere, and it's time to, particularly when it comes to qualified immunity, start righting the ship and making sure that we can hold the government more accountable, the police accountable when they do stuff like this. Rob, could you kind of just walk us through what the opinion did and didn't do, and kind of just help us understand why, Bob and Addie, when they were reading that opinion, had this roller coaster experience? What is it that was giving them that sensation?
Well, first, I want to say that, I think the opinion is a great triumph for the Fourth Amendment and for individual liberty. Anytime you prevail in a qualified immunity case against law enforcement, it's a reason to be elated. If you look at the opinion, and it is 100 pages, it's the very first paragraph that's far and away the most important. This is the paragraph where the court was speaking with one voice, where all three judges were in agreement, and where the court was explaining the disposition of each claim in the Harte's appeal. The court did affirm the district court as to some of the claims, the what lawyers call the excessive force claims and claims against the county itself.
So basically the appeals court said that when you say affirmed, the district court got it right when it ruled that the Hartes couldn't go forward with the excessive force claims. Is that right?
That's right, as to a couple of the claims. But the most important takeaway is the appellate court held that a majority of the claims in the case could go forward to a jury, that a jury could hear evidence as to most of the claims relating to the police investigation and the possibility of untruthfulness that unfolded in the investigation, that the case could go forward as to the unlawful search and execution of the warrant. The case could go forward as to the claims brought by the Hartes under Kansas state tort law.
So I think that's a really good point and a reminder. And I completely empathize with Bob and Addie Harte and kind of the reaction to, the claims that they can't proceed on. And that's really disappointing, right? But as you said, this does have a good outcome on some of their claims, and that's important. I think that, most people don't realize how difficult it is to prevail at all on a Fourth Amendment claim. I mean, as Bob says, like if you just look at the plain facts of what happened, I think most people would say, gosh, it can't be that the government can do this type of thing in the first instance. And second, it can't be that they then can't, be held accountable for it. And I think that's that's an important takeaway.
Rob, any final thoughts?
Government overreach is something that we should all feel strongly about. And when I look at the case, I see Bob and Addie Harte, who have been fighting for years. And this case, in my view, shows the role that brave litigants, brave clients can play in moving the direction of constitutional law and in protecting civil liberties.
We have come to terms with the fact that whether or not, or however this means to us personally in the case, that the fact that we're impacting the law in a measurable way, and the fact that, hopefully law enforcement practices around the country, not just within the 10th Circuit, might be taking some instruction or notice from this, is really powerful. I have to tell you that this process and of continuing to pursue this is incredibly disruptive and painful for us in any number of ways. But again, if we can't do it, and if we can't teach our kids that this is not what it means to be an American, then we just have to continue to fight this.
Okay, that concludes the show. 10 minutes after we finished recording, we learned that the government has asked the 10th Circuit to reconsider the decision en banc. If the request is granted, the ruling would be vacated, and a panel of 11 judges would rehear the case. Thank you for listening, and thanks to Addie, Bob, Cheryl, and Rob. As always, please email us at shortcircuit@ij.org with comments and questions. Until next time, this is John Ross from the Institute for Justice, inciting you to get engaged.